indicated, I am a labor and employment lawyer. I work at PooranLaw. Many of you may know Brendan and Cheryl, Pooran and Wiles Pooran, who of course run the firm. I'm one of the lawyers who works with them, frequently assisting with families that are either setting up microboards, operating microboards, or learning how to or helping to manage various challenging employment situations that can arise. Because of course, one of the big values of a microboard is it is a vehicle to help support and protect you in an employment relationship. So part of what we're going to be doing tonight is talking about some of the best practices around setting up employment relationships, managing employment relationships, managing contractor relationships in the microboard context. And that's, of course, something that our firm does quite frequently. And so we're hoping to target that tonight to your specific needs. As Karen indicated at the end, I'm happy to take any questions. Just given that we're recording, I might save the questions till the end, unless we do want to include those in the recording. But with that, I can get right into some of the agenda for tonight. And I'm just going to advance us to the next slide here. Excellent. So we're going to walk through a number of topics tonight aimed at really giving you a detailed tool set of some of the things to think about, some of the things to do, best practices as you look at hiring people to support the person the microboard is aimed at supporting. And we're going to walk through some initial little bit of legal background to help you understand how does employment law work in Ontario? We're not like the United States. We're not even like some other Canadian provinces. We have our own system. Unlike the US, for example, you can't fire somebody at will. And we'll go into some of the rules around hiring and firing, for example. We're going to go into some of the basics of class funding, some of the basics of classifying your worker. Classifying your worker is, of course, something you'd be wondering, what does that mean? And we're going to talk about, well, in Ontario, there's the distinction between somebody who is your employee, who you have many more obligations to, and somebody who is a contractor, sort of like hiring, let's say, somebody to fix your roof. They're not your employee. They're somebody you hire to do a job, and you have less obligations to them. We're going to go through some employment relationship fundamentals and best practices, some contractor relationship fundamentals and best practices. And in both of those, we're going to talk about how best to protect you, how best to make sure that you're complying with your legal obligations. So one day you don't get a surprise knocking on the door with a demand letter saying you haven't paid this employee what they're required to be paid or something along those lines. And we're going to make sure that it is as least scary as we can be in advance. As long as you go in knowing what it entails, you're in very good position to prevent that from happening. And even if it does happen, you're in a good position to help protect yourself. We're going to go into some human rights and health law basics, some payroll tax considerations, some introduction for insurance, and some of the considerations for what sorts of insurance to have in place. And this is a big one as workplace injuries have become more discussed over time. It's one certainly coming to the forefront. We'll talk a bit about best practices for using staffing agencies, hiring somebody to come in who actually employs somebody else to provide those workers to you. And that's a bit of a crossover between contractors and employees we'll get into, and one that can be quite useful for families in need of providing support workers with some lesser obligations, but certainly not no obligations. We'll talk a bit about some special classifications of workers. And what I mean by that is the law in Ontario recognizes some types of workers that have different rights tailored to the unique needs of people like microboards. So for example, workers who can live full-time in a home without being paid for every hour they're in the home in order to provide 24/7, more or less on-call care. And so we'll go through some of that. And then we're going to round off with what I would call the signs when it's time to get some additional help. And that might be a lawyer, that might be some more specialty legal advice, but situations where you know it might be time to get a specialist in. And so we're going to navigate that all together one by one, starting with our legal background. And so as I said, we're going to walk through a bit about what are the fundamental concepts of employment law that we should know going in and thinking about when we want to hire somebody? Well, employment law in Ontario really comes down to contract. What that means is you're contracting with somebody to essentially be a worker who responds to your direction. They work usually exclusively for you during the times they're hired by you. They take your direction. Direction's a big part of it. You control the way they do their work. They typically operate at either a fixed salary or a fixed hourly rate, things like that. And it's a contractual relationship. And what a contract is an agreement between two people that is an exchange of promises. The classic example of employment is I agree that you agree that you're going to do work for me, and in exchange, I'll pay you money as an hourly wage. That's an exchange of promises. That's a binding legal contract. Now, that can be classically a written contract. That means it can be a document that you both sign saying, I agree I'm going to pay you X amount. You'll agree you'll do Y duties for me. It can also be verbal. And that's one that I think not a lot of people necessarily know in Ontario, but intuitively it makes sense. You can hire somebody to work for you, and you have a verbal agreement that your wage will be $17 an hour. And that's considered to be a binding contract in Ontario for the most part. There can also be implied terms of the contract, and that's getting a little more into the nitty-gritty, so I won't go too detailed with that. What it means is where you do have a contract, and it could be that a written contract, it could be the verbal contract you have with somebody to do work for $17 an hour. There are terms you may not address. You might not say what happens when somebody is dismissed. You might not say what happened. I mean, that's the classic one I'm going to stick to. You might not say what happens when somebody gets fired, for example. And the law in those circumstances can imply in terms to cover those scenarios. Basically, think of it like the law filling the gaps. And that can be another way we think about contracts. So all this to start with is it's agreements between you and your employee or you and your worker. And it can be with employees. It could be with staffing agencies that you hired to do work for you. That's a classic one where you're going to want some sort of a written agreement. It can also be through self-employed workers. So contractors, people who basically might own their own business. They might support multiple families, multiple agencies, and you would still have a contract with them. Now, one of the biggest questions we see here from families is my worker an employee or a contractor? And this has pretty big implications. I've already indicated a little bit that employees have more rights than contractors. And so it can be a really live issue, a big issue. And we're going to speak to that a little later on in our presentation about how to think about that issue and how to weigh the pros and cons of the two different relationships, how to avoid what can be a pretty big surprise if you find out your contractor is actually an employee. But we'll get to that in a little bit. Just going to put a pin in that now. I will say that the law of employment in Ontario really has two sources. One is laws that the government passes, and that could be the Employment Standards Act. That's the classic one. That's the minimum level of rights every employee has in Ontario, set out in the Employment Standards Act. That sets the minimum wage, maximum hours of work, minimum vacation pay. All of that's in that law. Now, the government passes other laws too. For example, the Human Rights Code. We'll talk a little bit about that. But it isn't just the laws that government passes that matter. There's also what we call judge-made law. You might have heard of this called the common law. And this is something we borrow from ancient England, or medieval England anyways. All it means is that judges looking at cases coming before them have made rules about how to deal fairly, in their view, with disputes over time. And so, for example, when somebody is fired, there's a common law approach to the amount of notice they're supposed to get before they're fired. And so that's judge-made law. And that can be obligations. Sometimes the laws like the ESA will replace judge-made law. Other times, judge-made law will be something that, unless you say we're going to contract out of it and go to the lower standard, will apply above the minimum standards set by the legislature. Now, I realize that's a lot of information and background. All I think you really need to know for the moment is that a contract, sort of any mutual agreement between you and a worker, and the where law comes from in Ontario are those two sources, either what the legislature, what the provincial government passes, sometimes the federal government, we won't get too much into that, and what the courts say. Now with that, I'm going to go a little more into the Employment Standards Act. Now, signing one of the things we've gone into a little bit here is this distinction between an employee and a contractor. We'll go into the two separate rights. What I will say at this point is that the Employment Standards Act, that minimum level of obligation that is set by the provincial legislature, has some rules I do need to flag now. One is that having a contract, just saying a worker is a contractor, or that a worker is not an employee, doesn't automatically make that law not apply to them. It's going to be something that comes down to the substance of the relationship. We'll get into that test. Another thing is that you cannot say, and this is the big one, you cannot contract below the ESA minimums. You can't have an employee waive ESA minimums. You can't have an employee say, I agree, I'm going to get 0 vacation, for example. Now, none of you, I'm sure, would get into anything that's an extreme example, but it can be very, very tricky navigating whether or not an employee can work above ESA's maximum hours of work. That's a less clear one. But the clear thing is, you cannot contract out of the ESA unless it says you can. And most of the time you can't. A worker who's an employee has to receive at least those minimum Employment Standards Act obligations. If they don't, they're going to be entitled to them in retroactive terms. The limitation period is generally 2 years. So that potentially after 2 years of whatever that benefit is backwards, you might be hit with administrative penalties. The Ministry of Labor can sometimes issue orders saying you should have done X, Y, Z, and we're going to apply a penalty against you. And we're going to order you to do it going forward. In extreme cases, they might do, the Ministry of Labor can charge an employer with an offense, which is like, it's not a crime. It's something more than a penalty, like an administrative penalty, but less than a criminal offense. It's basically the government saying, we think you have broken the law, and so we're going to do something more serious. We're going to apply a more serious fine, and some limited circumstances, jail time. It's pretty rare, I will say, except for big employers for the most part, or employers who do egregious things. We have to tell families, as this is always a tail end risk, we have to tell people who operate microboards, but generally speaking, this is not the big thing you're going to be worried about. For example, there's an offense saying that you can, if you classify a worker as a non-employee when they should be an employee, that's an offense. It's very rarely ever charged. Usually the way this gets dealt with is the employee says, I want to just receive whatever I would have received, and that's what's ordered, maybe a penalty, and the offense is left for if they really want to, lay down the law with somebody. But the ESA is important to follow, an important part of our background here. All right. Let's talk about classification. This is what I was talking about before when we're talking about employees versus contractors. Now, how your worker is classified is going to determine what their rights are and what your obligations to the worker are. And generally, there are two types of classifications. There's employees and what we call independent contractors. Now, you might be thinking, well, if there's an independent contractor, is there a dependent contractor? And there is. We're going to get into that in a little bit. And it's kind of a middle ground. But the two you really need to think about are employees and those contractors. Now, many families choose to treat their workers as independent contractors. And that's typically because it's simpler and easier to do. There's benefits for you. It's a less complex payment structure. You're not reporting income for the worker. You're not making deductions at source. Your record keeping is easier. but it can be quite risky. Unless you're sure the contractor is really a contractor. Unfortunately, we've seen situations where somebody is hired as a contractor and the relationship breaks down in some way. Maybe there's a fight about compensation. Maybe the employee's let go. And suddenly the worker's claiming, well, actually, I'm an employee. I should receive 2 years worth of retroactive vacation pay, or I should receive notice of my termination beyond what you would have given to a contractor. And having an agreement that they're a contractor, having treated them as a contractor, isn't going to be the definitive part of whether they have a claim. So how do we know what the proper classification is? How do we decide that? Well, as we said a few slides ago, a key question is whether the worker will, or a key question to decide here is that there is no, or I was going to say that what we were talking about a few slides ago was that it's important to know whether or not this employer or an independent contractor. We're going past that part. The way to determine that, there's unfortunately no clear test, but there's some general principles. It's decided each case on its own facts. There are some which are clearly employees. There are some which are clearly contractors, and there's a bit of a mushy middle. Now, it's important to keep in mind the intent of the parties can be a factor here, but it's not the determinative factor. That's the first one. What did you mean to do? What did you and the employee together intend? Courts or the labor board or the Ministry of Labor, they can take that into consideration. If you say in a contract, this person's a contractor, they're not going to kick that away, but it's not going to be the only factor they look at. In contrast, if you say and I've seen this before in my own practice, if your employment agreement or your agreement with your contractor says this person's an employee, you're in a bit of a rougher spot. Because then you have something saying very clearly you intended to treat this person as an employee, but you've actually been treating them like a contractor. The second factor that's very important is control. Who has control over the workplace? Who has control over what the employee is doing? Now, you will have some control over a contractor. You'll tell them what you hired them to do. You might criticize some of the output of the work if you're not happy with it. I mean, if somebody comes and screws up repairing your roof, you're going to tell them, I'm not happy with this. But you have much more control over somebody you hire as an employee. You actually supervise their work. You tell them, I don't want it done this way, I want it done that way. You have much more control over them. And with control also comes more dependence by the worker. The worker is more dependent on you. You have the factors there that they are going to typically, they might work solely for you. They don't have their own business. They have a wage that's important to them from you. That's another factor in favor of employment, not contracting. In contrast, if a worker has multiple clients, your business is important to them, but you're not their only client, that's going to be more towards contracting. How regularly they work for you is another factor. Somebody is working for you all the time, a couple times a week. That tends to lean more towards employment. Not necessarily. You can have contractors who also work for you multiple times a week. We do see it. And those people, if all the other factors go towards them being a contractor, are probably contractors. But somebody who only works for you once a month, for example, maybe a respite worker, that person is much less likely to be an employee unless other factors push really strongly towards it. Another factor is ownership of tools. Now, this one can be, I think, simplified a bit. What that's getting at is if somebody's supplying their own equipment. For example, if they are driving their own car to drive around the person they're supporting, if they are providing their own workplace, for example, if you're dropping off the person they're supporting at their home where they operate their services, that's somebody who's more likely to be a contractor. But if they're coming into your home, for example, or you're providing a car, or you're providing equipment to them, that tends to lean towards employment. Pay arrangements are another big one. So for example, if somebody is a contractor, the types of things we're going to expect are they're invoicing you. They're giving you an invoice every pay period. And that invoice will say, have HST on it. And there's agreement they're going to charge HST. And you're not issuing deductions on their payroll. You're not issuing a T4, a tax form like that you give to an employee. Those things tend to weigh in favor of contractors. If you're making deductions, you're using a T4. If they're not invoicing you, if they're not charging HST, or at least not acknowledging that HST could be contemplated, there are some circumstances where a worker who is a contractor won't charge HST. That can lean towards employment. Other factors here, risk of loss. What that's getting at is when somebody's salaried or somebody works by the hour, they tend to make the same amount of money no matter how operations are going. In contrast, if somebody's operating their own business, they might provide you a service that costs more to provide than they earn from providing it. That doesn't come up as much in the microboard context. It's more when you're in for-profit industries. It can, and chance of profit's the same thing. If they're not earning a fixed wage but can make profit off what they're doing. In my experience, that doesn't come up as much, but it's still an important factor. The duration of employment, if somebody's hired for a short fixed term, like a week's worth work, that might be more like a contractor, that you can see employees like that. And if somebody's been working for you for indefinitely, for years and years, you start to get into employment territory if you're not careful about how you structure that. So there are also some workers, some employment type arrangements is the last factor here. What we're talking about there is some relationships are just inherently structured like employment. So for example, when somebody is portraying themselves to the world as I'm a representative of this person. And the classic example of that is if you go to Starbucks and the person at the counter is wearing the Starbucks uniform while they make your coffee, they're presenting themselves as an agent of Starbucks. They're going to be an employee of Starbucks in all chances. That's another factor which is a little less important in our setting, but if they're being represented as your agent in whatever they're doing in their services, that can be a factor, not quite as important for us. So how do we weigh all this? In each case, you look at the whole, every factor together and say, do I think it's more like this? Do I think it's more like that? Sometimes you have clear cases. The big one that tends to sink people is when the contract says this person's an employee and you don't want them to be, because courts tend to look at this as a pretty employee-favored analysis over employer. But you weigh it all together and see what you get, and generally, hopefully, are clearly on one side of the line or the other. And if you're not clearly on one side of the line or the other, there are ways to, I would say, make your intentions clear and restructure the relationship to get on the side you want to be on. Now, let's talk a little bit about, to put this into real perspective, things that are actually a little more grounded in what you might be seeing day to day, some different types of workers and where they tend to fall on the spectrum based on the type of work they're providing. So starting with sitters, generally speaking, sitters are more contractors. It's the sort of intermittent work you're hiring somebody to do. Typically the way you're paying them. I mean, you may not even have it be on paper for the most part, but generally speaking, these are not people whose work they're dependent on you for their work. They're not, I would say, working for you a great deal. It's sort of intermittent, generally not going to be an employee. That can veer more, if you call somebody a sitter who's actually working for you all the time, that can be more where the substance moves towards actual employment. But generally speaking, a sitter, as most people tend to think about it, is more likely to be a contractor. Live-in support workers, these are very hard roles to make out as contractors. It can be done, but for the most part, we tend to see live-in workers as being employees. And that's because you tend to have much more control, much more exclusivity and dependency, and so on, over somebody who actually lives in the workplace where they provide their services. So it tends to be more employees in that circumstance. Now, professional workers, so think therapists, tutors, coaches, and so on. Those types of workers generally seen as contractors. And that's because they tend to have much more control over the work they do. They have less dependence on you. Generally speaking, they don't provide exclusive services to you. And that just makes sense to most of us, I think. We don't hire our doctor as our employee. They're a contractor that we hire to some degree. Same with the other sort of professions we mentioned there. Now, full-time support workers, they're typically going to be employees. And that's given the amount of control over you have over them. If they're working full-time for you, they tend to be exclusive for you. Not always, but have a high level of exclusivity, a high level of dependence. That tends to be pretty determinative in their cases. Part-time support workers, that can depend a bit. It's going to depend a lot about how you structure their work. If they work for multiple people and operate as their own business, so if they put themselves forward as, this is my business, it's got its own name, I have multiple clients, and that's how they put it to you. They invoice you. You allow them some independence in how they do the work. That's going to be potentially a contractor. But depending on if you have that same person, they might work for other people. But if you're exercising more control over how they do their work, if they don't operating their own business, they're just somebody you've hired. If they, especially if they are not working for other people, and if they're working indefinitely for you, so no fixed period, it's just as long as you need them for, that's somebody who's more likely to be an employee. And that makes sense to us. Lots of people work multiple jobs. They're not contractors, they're employees. But part-time workers are really an area where you have some more freedom how you structure that relationship. Now, finally, respite workers, they tend to operate as contractors, and that's given the short-term nature of their work. Respite depends on, how much they actually are a contractor or not, really depends on the frequency, whether or not you're their sole client, but the nature of respite work does tend to be generally contractor work, particularly where it's being provided in a workplace that the respite worker actually owns or operates, that isn't yours. Now, in contrast, when they're actually providing it in the home operated by the microboard, you tend to have potentially some more risk, but even then you can tend to have people be contractors. So that's how we think about each of these roles. And I realize at times it could feel a bit like splitting hairs, but it ends up being very important for reasons that we're going to get into. And we're going to start with employees and emphasize and outline what some of the obligations towards employees are for microboards. And that's going to, I think, demonstrate. Then we're going to go into contractors, and that'll show a bit of that distinction. So we've summarized here some of the nitty-gritty details of the legal obligations, some of the most important legal obligations that microboard employers will have to their employees. And this is separate from those special cases we're going to get into of people who are specifically tailored to work in these sorts of settings. We're going to get into those, but this is any employee you hire by default will have these unless they fit into one of those later exceptions. So we have those key rules on the slides there, and these rules, generally speaking, come from the Employment Standards Act. There is a little bit of common law up there, starting with the minimum wage. Now, if you've been reading the news, you may have seen that in Ontario, the minimum wage recently went up to $16.55 an hour, and that applies to almost all employees. There are some special classes, so students, for example, have a slightly lower minimum wage, and it's typically talking about minor students, not adult students. But $16.55 is the number you want to be thinking about. And that's either the base wage you have to pay an employee, dollars per hour, or if you salary your employee, all their non-overtime hours averaged. And that means, let's say an employee works 40 hours in a week. You would take whatever they're earning that week, maybe it's $1,000, and divide it by 44, and that average hourly pay has to be at least $16.55. So that's really important, because if you don't pay an employee the minimum wage, and that employee later makes a complaint about it, you can be hit with retroactive pay for that employee going back up to 2 years. Now, some of the ways that manifests is sometimes we'll see employers pay employees less than minimum wage for sleep shifts, let's say. Or when an employee just has to be in the home, but they're not doing anything. And in those circumstances, you can get into a bit of trouble. Certainly, I think the default rule is even in those cases, if an employee is required to be in the home and respond to a call for work, in most cases, they have to be paid at least minimum wage. Then we get into overtime. And that's another classic, really important piece of the ESA. And all that's saying is that if an employee works more than 44 hours in a week, they're entitled to a premium for overtime for every hour worked above 44 hours of 1.5 times their regular pay. So if they earn $20 an hour usually, but they work 45 hours, they're entitled to 1 hour of overtime. 20 times 1.5 is 30. So that's another important one. Then there's vacation entitlements. Now, vacation in the ESA has a two-tiered system for short-term employees and longer-term employees. If you're somebody who's worked for an employer between 0 and 5 years, you're entitled to 2 weeks of vacation per year and vacation pay equivalent to 4% of your gross wages. So that can be paid out in multiple ways. That the time has to be taken, and the time continues to accrue whether an employee is earning money or not. They're entitled to 2 weeks off, but they're only entitled to pay as a percentage of what they've actually earned. So for example, if an employee earns, let's say, $40,000 in a year, they're entitled to 4% in addition to that as vacation pay. And that can be paid out every paycheck if you want. That can be paid out when the employee takes vacation. Pay it out on 1 day a year if you want. The rules are pretty open to you and the employee agreeing how to pay that. A lot of employers we know pay it out every paycheck as here's your share of vacation pay. When you take your time, you'll have to use the money we've paid out to cover you for that. But it's really important to provide that vacation. And that vacation typically has to be taken by default. It's in a 1 week block. We've seen you can agree with your employee to do it as a day here, a day there, but you're entitled to require it as an entire week if that's what's convenient for you. You also get to pick when the vacation's taken for the most part, unless you contract with the employee to decide when it is taken. As a general HR practice, it's a good idea to get the employee's input and give them their preference to the degree it's possible. It's good for morale. It's good to let the employee, structure their life. But it's always important to know you do have by default that power to decide when it's taken. After 5 years, the employee goes up to 3 weeks vacation a year and 6% of gross income or gross wages as vacation pay. Important to keep that in mind. It goes up after 5 years. And that's where it caps out. We do see some people contract for more. I've seen agencies, for example, and we're talking about not Microboards here, but large employers that offer 6 weeks vacation a year for very senior employees. You don't have to do that by law. That's something you agree with your employees if you want to provide it. Typically, we see a lot of employers hew to the minimum here. Then we get into public holidays. So public holidays are, there are 9 in Ontario. They're days that everybody generally gets off, Victoria Day, things like that. And you're entitled to have it off with pay. That pay is calculated as being, you take all the earnings for the 4 weeks before the week that the public holiday happened in. So the 4 weeks before the week Christmas happened in, for example. You add up everything the employee earned during those weeks, and then you divide it by 20, and that's what the employee's paid for their vacation day. Now, you can have the employee agree to work on a public holiday day, or if you have a 24/7 continuous operation, as a lot of microboards do, you can require them to work on a public holiday. It's a good idea to have that in whatever contract you have, that's a clear expectation to avoid fights. If you do that, you have to either pay the employee time and a half plus vacation pay, or straight wages for that day and a substitute public holiday within the next 3 months. Won't go too much more into that. Another piece that employees are obligated to, or employees are entitled to, is certain unpaid leaves of absence that the ESA provides them. Now, what we're typically looking at there are, pregnancy, parental leave. And that's up to, I believe, a combined 63 weeks now, if you take both pregnancy and then parental leave. Or it is, sorry, no, it's 17 weeks pregnancy and then either 61 or 63 weeks of parental leave, depending on whether you also took pregnancy leave or not. But it can be a significant period of time. And you're not required to pay an employee during that period of time, but you're required to continue benefit premiums if you do that, if you provide benefits. The employee continues to accrue length of service, which can be relevant for other factors. There's other leaves as well, 3 days of unpaid sick days, 3 days of family responsibility days, 2 bereavement leave days. Again, all of those are without pay, with the exception of there is a sexual and domestic violence leave, which does have some pay continuity for a few days. But for the most part, it is unpaid. Termination. That's another thing employees are entitled to that contractors aren't. Contractors, for the most part, you can fire them with no notice unless they contract for notice. Employees, on the other hand, are entitled to a minimum of notice under the ESA. Now, for most microboards, that notice is between 0 and 8 weeks, either of working notice or pay in lieu of notice. So what the employee would have earned had they worked that period. 1 week per year of service, up to a maximum of 8. Now, if you're a larger employer and you have a payroll of 2.5 million a year or more, you might also owe severance pay on top of that. But for the most part, I don't think I've ever seen a microboard that has an operating budget that big for payroll. Then at that point, you're not really a microboard anymore. You're just a board. Now, common law on top of that, before I get to common law, sorry. In addition to that working notice, you're required to continue benefits participation for the length of that statutory notice period. So if it's an 8-week notice period, for 8 weeks, even if you just pay the employee at 8 weeks. So those are the 3 things you're required to give: severance pay, termination pay, benefit pay. For the most part, you don't have to worry about severance. But there's also common law notice. And this is what really hammers microboards if it's missed. Common law notice is that judge-made notice that we talked about, judge-made law, that says we think employees should receive reasonable notice when they're fired, or if they don't get reasonable working notice, the money they would have earned had they gotten it. You might say, okay, well, how much is that? And it can be a lot in Ontario. A general rule of thumb is it's 3 to 5 weeks per year of service, up to a maximum of 24 months, sometimes longer. Now, I will say, in the developmental services sector, there's a huge labor shortage right now, and there's something called a duty to mitigate. And so a lot of the time you can get that reduced by saying, well, did you look for work elsewhere? Could you have worked elsewhere and made that money? And if the employee didn't make efforts to look, or they did work elsewhere, then money's deducted against what would be owed. But that can be a big, scary amount for families. But the benefit is that if you do it right, you can actually contract out of common law notice. And that's pretty appropriate where you're a family, you're not a big company. And so that's one of the benefits of getting a well-drafted employment contract by a lawyer, for example, is they can provide some protection against you from that obligation. But it's something to be aware of when you hire an employee. Last 2 things here I'll say, before moving on to contractors and cognizant of time here, is that there are protections against reprisal in the ESA. Now, reprisal is just punishing an employee because they tried to enforce their rights, or they didn't enforce their rights, or they took a leave of absence. When that happens, if they are negatively treated by an employer, that's a breach of the Employment Standards Act, and you can again be dealt with through back wages, penalties, maybe even an offense. So important to keep that in mind. The other thing I'll say is that there are exemptions to these rules that I've alluded to. For example, we'll talk about something called a residential care worker or a domestic worker. Residential care workers are exempted from overtime, some hours of work limitations, and we'll get into hours of work when we talk about them, pay for certain hours of time, and that can be important for smaller operations. Some other employment obligations here that are important to note. You also have human rights considerations. You have to accommodate employees if they have human rights needs that conflict with their work. You have a duty to provide a workplace free from discrimination. and to accommodate employees who face barriers in the workplace due to protected grounds. So for example, disability, or if somebody would usually work on a Sunday, but they need that time to attend church services. Now that duty to accommodate means you have to potentially modify the conditions of work, so long as it doesn't constitute what's called undue hardship. And that means there may be some costs. You may need to hire a worker to come in on that Sunday instead of the worker, or you may need to provide slightly, different workplace layout to the degree you can afford it. But it's something you need to at least consider and think through if an employee has that need and brings it to your attention. Now, undue hardship, all that's getting at is that eventually it can be too expensive, though, and that's a defense. If something is so expensive that it would actually be a major impact on your budget, if accommodating somebody would violate health and safety, we saw a lot of that during COVID-19 when people said, for example, I can't wear a mask, perhaps because of a religious reason. And we would say, all right, well, we take that in good faith. It would be an undue health and safety risk for you to support this person because maybe they're medically vulnerable. And that relieves you of the duty to accommodate. Generally, we'll get at the end, good idea to get a lawyer involved at that point. There's also health and safety obligations. Most of the time, you're going to have health safety obligations under what's called the Occupational Health and Safety Act. It's Ontario's workplace safety law. And that includes obligations to protect employees from violence and harassment, to ensure a safe working environment, and ensure they take minimum mandatory training online that the government issues on health and safety. And there's a little course the government puts out there they have to take when they start employment. There's also obligations to the CRA and Service Canada. And that's to make certain deductions for employees for taxes, CPP, Canada Pension Plan, and employment insurance premiums. And then to supply the employee and the CRA with the requisite tax forms, so T4s, in some cases, T4As. When you let an employee go, a record of employment that sets out, when they worked for you for, and that's for EI purposes, and so on. There's also obligation to provide WSIB coverage in most cases. Now, there are some exceptions for WSIB. So certain domestic workers who work less than 24 hours a week, for example. But for the most part, most full-time employees and a lot of part-time employees in Ontario are required to have WSIB. Now, WSIB is just the government's mandatory insurance scheme for workplace injuries. The employer pays premiums into it, and if a worker is injured, rather than being able to sue the employee has to go through this scheme to get coverage. And that is actually a benefit for employers because it means an employee can't sue you if they're hurt. But the premiums can be expensive, more expensive than private insurance. And as I say, most workers have to participate. There are some limited exemptions. And that has to be set up in the first couple of days that a worker is working for you. Now, finally, an employee may be entitled to common law notice. We already talked about that. I won't go over it again. So quite a few obligations here. And most of these don't apply to contractors. So what are some of the best practices for managing your obligations here? Or best practices for hiring an employee in general? Before we move on to contractors. Well, first, it's a good idea to screen your workers to make sure they're the right fit for you. And that's things like vulnerable sector police checks. That's invaluable. Is this the type of worker who has, let's say, a criminal record that would be relevant to the work they're doing? Or even are they being charged criminally with something that's relevant? Maybe they engaged in criminal fraud and they're going to be overseeing finances for you. That's a pretty concerning, factor to know about. Doing reference checks. So for example, calling the last few employers to see how is their work. And you can typically read through, if somebody's being very cagey about what they're saying, that's a red flag to think about. Not necessarily, the death knell, but if somebody, let's say, is only willing to comment on a letter of employment and say nothing more, that's one to sort of make a note about and maybe think through, is there something more here? The other big thing is to have a written agreement and a properly drafted one. And that's where a lawyer can be useful or using a good guide, something like that. But a written agreement to limit your liability, particularly around the end of employment. So limiting that obligation to pay common law notice, because that can be one of the heaviest impacts on a microboard that hires a worker if they ultimately let them go, particularly if it's a long service worker. It's also a good idea as a tool to communicate expectations. It's less likely you're going to get into a fight about something if it's just stated in your contract. But important to draft them properly. I will say it is getting increasingly difficult to correctly draft a termination clause. The courts are getting more hostile about it. It can be done, but generally it requires some amount of legal expertise, but it's sort of it costs a little more upfront, but it can save you a lot in the long run. Excuse me. A generally good idea to know your obligations under the ESA. There are a number of more detailed guides out there to help employers understand that, some of which are general. I know Community Living Ontario has put out a guide that we helped draft specifically aimed at workers or aimed at hiring support workers in the family context, but it's generally portable over to microboards. And so understanding that, it's a pretty useful tool to help avoid getting into hot water down the line. Consider exemptions. That's another big one to limit your liability. Is this a residential care worker? And again, we'll talk about that towards the end, but it's just a factor to think about and get some advice on it if you need it. Avoid reprisals if an employee tries to use their rights, or even if they just bring up their rights and say, I think I might have the right to this. Be very careful about taking any action against them that could be seen as punitive. So for example, saying, you're not a team player, so we're going to let you go. I would generally be open to discussing these things, but just be very careful about doing anything that could be seen as a reprisal. Register with the WSIB if it's appropriate, or ask if you should register. Generally, as soon as you can after an employee starts. If you don't have to do WSIB, it's always a good idea to still get coverage either through the WSIB, if that's the route you want to go, or by hiring alternative insurance. And that's just to protect you. We'll talk about insurance down the line. Register a business payroll number for CRA purposes. Make sure you're properly making deductions from payroll, things like that. Consider using a payroll service like Ceridian or ADP. There's also smaller support organizations specifically aimed at helping small microboards, for example, or helping families do this type of work, people pulling their resources together, and then keep proper records. Now, records to some degree are required to be kept in ESA anyways for employees, but generally speaking, good payroll records help to make clear when you did or didn't pay an employee. That leads us into contractors. Now, contractors have a lot less in obligations. A number of benefits from hiring them is contrasted with employees. First, you don't need to worry about deducting income tax or CPP or EI. You generally don't have to do much reporting at all, no T4. The contractor is responsible for doing that. They're supposed to report their own taxes and use their own forms. Technically, and in some cases, you need to issue a T4A, which is a tax form aimed at self-employed people you hire. But overall, not much reporting there, much less administrative burden on you. 2, the general rights under the ESA don't apply to true contractors. That means no paid holidays, no vacations, no limits on hours of work, no overtime, and so on. And think about it. If you hire somebody to fix your roof and they hire a contracting company, it's not your responsibility to think about their vacation time, their overtime, things like that. That's within their own organization. If you end the relationship, you generally don't need to pay reasonable notice. It's only whatever's in your contract. And this is where we get, though, into this thing we had talked about before of a dependent contractor. An independent contractor, you're in the clear. An employee, you're on notice to. But a dependent contractor is somebody who's just employee enough that they end up getting reasonable notice. This is a bit of a vague concept, and I don't think it's too important for us to get into too much detail with, but it's sort of somebody who is dependent enough. They have their own business, let's say, but they only work for you. And they have a mix of these factors. The court might say, well, yeah, they're a contractor, but we think they're sufficiently dependent that they should get reasonable notice. And the clear thing there is just, again, strong contracting helps protect you. identifying, if, for example, if you start to think this person's only working for me, even if they have their own business, you don't let them work for anybody else. But it's not really too much of a concern for most families and most microboards. Another contractor piece. There's no obligation for you to enroll them in WSIB. They might do that themselves, not for you to worry about. You also generally don't have obligations under OSHA in many cases, but do be careful, as the OSHA and the Human Rights Code, I'll say, both define employee in a slightly broader way than some of the ways we've talked about. All they really care about is control and dependence, not the other factors. And so you can end up with situations where somebody might not be an employee for ESA purposes, but still have entitlement to the Human Rights Code or OSHA. But generally speaking, you have many less obligations in this respect. Doesn't mean go create an unsafe workplace or go and, say, well, I'm not going to worry about, providing a good human rights workplace, but it does mean you're at less risk. So as we can see, there's many lesser obligations for somebody hiring a contractor. The risk, of course, is that you'll wake up one day and the contractor will say, I'm actually an employee. Now give me all the things I was entitled to as an employee, retroactive to 2 years, or give me notice. And so how do we help to protect ourselves here? Well, we do have some recommendations. First, like employees, we recommend good screening up front. It's not inappropriate to ask contractors who are going to be providing supports to somebody who is a more vulnerable person, to provide a vulnerable sector screening check to make sure that they have an appropriate background for this. Maybe reference checks on their work if it's appropriate. In hiring the contractor, make their status as a contractor clear in the recruitment and engagement process, and don't give the impression that they're going to be an employee. So for example, make clear, you're going to be a contractor. We're hiring you as a contractor. Don't tell them that you're going to be an employee at any stage. And then make sure that your written agreement with them, whatever it ends up being, clearly reinforces this is a contractor. Don't say they're an employee in there. Avoid that word altogether, except to say you're not an employee, you're a contractor. Make sure that the agreement you come up with them clearly identifies that they are going to provide you with invoices or receipts for what you pay them, and that they're going to report their income to the CRA, and they're responsible for doing that, not you. Consider whether this is one of the circumstances where you should issue a T4A to them. But generally speaking, make clear that they're responsible for their own tax filings. If I would add a line in there too, that if they're required to charge HST on whatever service they provide, they'll put that in their invoice and charge it to you. And that's just to say some small contractors aren't required to do that. Be very careful. As I said, don't use the word employee. I won't go over that again. Even if you have the perfect contractor agreement though, and you've thought about, yes, this person is a contractor, they're not an employee, it's still a good idea to check in and review every once in a while just to see, has this started to drift into something more like employment? Is this person working a lot for me and I'm directing their work? And, maybe they're not giving me invoices like they're supposed to, things like that. Just monitor on occasion to see, has this drifted in an area we have some risk and we need to tighten up the relationship to push it back towards clearly being a contractor? Because we do see families where that happens, where people have been hired, and then over the years they drift into effectively employment, the relationship breaks down, and then you have some risk. Now, finally, like employees, make sure to keep good records related to the relationship. So, for example, hiring and amounts paid, things like that. But also, I was at a conference recently where we were talking about how to recommend keeping documents, and it's always keep documents, but make sure to keep documents showing that you did things correctly. Documents showing you did things incorrectly can be tricky down the line. So I would sort of say it's a two-step process of doing it correctly and then keeping documents showing you did it correctly. And that's really your protection. All right, some payroll considerations. So for employees, what are some best practices here? Well, complete federal and provincial tax credit forms prior to the start of employment. As many people in Ontario have done when they started a job, you get a form from your employer where you fill out your tax credit status. I know I've done that on multiple occasions over the years, and I'm sure many of you have too. But generally speaking, that's something you provide at the start of employment. Set up a payroll account with the Canada Revenue Agency. Make remittances every month to them from payroll for income tax, CPP, and EI. Manage and maintain good payroll records. That's important. And complete tax filing. So a T4, for example, or a T4 summary. Use a payroll service. In many cases, that's a pretty good recommendation, using payroll. It just helps to make things a little administratively easier than doing it all yourself. You can do it all yourself. We know many people do use those services. Again, either the formal, ADP or Ceridian, or the less formal systems put up through mutual support networks. For contractors, you don't need to set up a CRA payroll account. Deductions and remittances are just the job of the independent contractor. You want to set those responsibilities out, like we said in the agreement. You want to get invoices before issuing payments. So, bill basically that you pay. That makes it nice and clear that this is a contractor. Manage your records and keep good records there. And if required, complete a T4A. Insurance. Let's go a little more into this. Oh, we're just going to click through this and get these all on the screen there. For some reason, it's doing a step-by-step appearing. So generally speaking, there are a few types of insurance you want to consider, starting with, for a microboard, directors and officers insurance, as well as general liability insurance. Now, directors and officers insurance, generally speaking, indemnifies claims made against individuals when they're acting in their capacity as a director or officer. For example, somebody might be sued by an employee of the organization because of a decision they made when they were a director. We've seen that on occasion. And this type of insurance, pretty standard, just helps to protect you from those sorts of claims, make sure that you're not at risk and out of pocket, because there is some liability associated with being a director. Directors are required to perform their duties to a certain standard. There are some obligations in the event of insolvency of the corporation, and this insurance just helps to protect you. And that can also include employer's liability. Generally speaking, we recommend coverage of at least $2 million just to cover all your bases, and that can generally be provided pretty economically. The other important insurance is general liability, and this protects against bodily injury, property damage, and so on, that the corporation will be liable for. Particularly, think about situations where a third party is damaged by the actions of an employee and they sue the microboard. In those cases, general liability are a real lifesaver, so to speak. And again, the minimum coverage we tend to recommend is $2 million just to cover your bases. But of course, there's also workplace safety insurance, which we talked about a bit before. I won't go too much into this, Morgan, other than just think about it. Are we required to be in WSIB? And if not, what's the best insurance that's outside of WSIB? And then vehicle insurance is another important one. This one really comes down to two factors. One is if an employee is supplying their own vehicle and they use that to transport the person being supported, you're going to want to make sure that their insurance is covering that sort of passenger carrying for employment. Sometimes policies have a rider to cover that. And you want to make sure that if the employee is providing that, they give you proof of insurance, or the contractor, if it's a contractor, that they are covered to provide passenger transportation. And again, it's a bit different. I would say this is particularly important where somebody's doing this regularly for their work. It can also be advisable, it can be a good idea to apply more insurance coverage if you're supplying vehicles for the worker to drive. And that's just sort of to cover your bases and make clear that your own policies are covering the work being done, and that you have sufficient coverage in the event of an accident. Okay, so that's some of the insurance considerations. Buying supports from agencies. Let's talk about that. So agency workers. These are workers brought in by a third-party help agency to provide temporary workers to support you, usually in a pinch. In Ontario, their status as employees are governed by the ESA. So they are primarily employees of the temp agency. They aren't fully your employees, but they do have some employee-like rights in connection with you, but they're just less than regular employees. And that can lead to some exposure for you, particularly if the agency you hire doesn't hold up their end of the bargain. So what are our recommendations? One of the best defenses is hire from a reputable agency. They tend to know and follow the rules and help to protect you. Who's a reputable agency is generally done through recommendations through organizations. Our firm knows a few that are generally well regarded, but there are also many others in the sector. And generally asking around, seeing where their reputation is. Have they been around for a long time? Are they a fly-by-night shop? All those are questions you want to be asking yourself. Make sure they're licensed. That's a new one coming out. So from the last time we presented this presentation, there's been a change in the law, which is the government of Ontario has adopted a new legislative scheme in the ESA, making clear that third-party agencies have to be licensed effective January 1st, 2024, and that employers can't knowingly hire an unlicensed provider. Now, there's a database online, and you can look it up, temporary help agencies database from the government of Ontario that provides a list of all the licensed agencies. And licensed agencies have to meet certain minimum rules to show that they are going to follow the rules. They're going to pay their employees properly. They're not going to disappear and leave everybody holding the bag. So it is actually better for employers. We're in a bit of a gray period right now where you can still hire temporary help agencies until January 1st without a license, but it is coming, so it's a good idea to start thinking about that. Make sure the agency you hire treats their workers as employees, because failure to do so can create liability to them and also to you if there's unpaid wages. One of the big obligations you have as somebody hiring a temporary support worker or agency is you are jointly responsible for unpaid wages that are made for the work done for you. Now, typically, if a temporary help agency doesn't pay their worker, the first person the worker is going to go after is the temporary help agency. But if the temporary help agency goes bankrupt or they disappear or they can't be reached, something like that, they can try and recover against you as the temporary assignment employer. So you're going to want to make sure to the degree you can ahead of time that the temporary help agency is properly treating their workers. And a good sign of that is, are they saying the workers are contractors or are they saying they're employees? For the most part, these workers are in substance employees, but there's a long history of temporary help agencies treating them as contractors to save some money. And of course, that can come back to bite everybody. Next, make sure the agency, temporary help agency, has either WSIB or some sort of alternative legitimate insurance coverage. And generally speaking, that's dealt with through they're representing to you that they have insurance, and they'll provide proof of that if you ask them. And failure to have insurance can create significant risks for you if an employee is injured. Now, again, the WSIB, fortunately, does provide some prevention of liability in those circumstances, but the cleanest way is just to have that protection. And if you don't have if somebody isn't required to be part of WSIB, that has risks of its own. Keep records of the work performed by agency workers, particularly of hours and days worked. This helps to protect you. And finally, make sure that the contract you have with the agency is clear about how much notice you must give each other to cancel the contract. It's a big one. It's key to ensure they can't leave you in the lurch, but also that you're not providing too much notice to them. There's one factor actually skipped over, and that's to make sure you have a written agreement with the agency that makes clear that they're going to warranty their work and indemnify you for any non-compliance by them with their own obligations or any third parties they harm providing the services. All right. Let's move on to special classifications, and then we'll finish off with some employment counsel, when to get us involved. Special categories. We've been talking about this on the margins all along. These are special classes of employees under the ESA, generally who live in your home or live in the Microboards property. that have specially tailored rights, let's say. And these are likely to apply to, these have a good chance of applying to many microboard settings. The first one is residential care workers. But before we get, I'm going to talk about domestic workers first, actually. Domestic workers, they live in the home that their employer owns and rents and live in, and they have some special rules allowing for deduction of some amounts from their wages for room and board, but generally speaking are the same. So all this is to say, if somebody lives in your home and it's a private domicile, they're going to potentially be a domestic worker. You may be able to deduct some of their wages as room and board, but otherwise generally the same. Residential care workers, though, are the really interesting. These are workers who live in family-style dwellings, they're called, that the employer owns or rents, but generally speaking, does not live in. They're exempt from certain overtime and hours of work rules. Now, what are the types of settings we're talking about here? Generally speaking, a home operated by a microboard, we think has a good chance of applying to that. It's not a family private house. It's typically a property owned and operated by the microboard themselves. It tends to fit into that statement of a family style dwelling. And if you meet that requirement, one, the worker is not entitled to overtime. Two, the worker has a maximum hourly rate or a maximum daily rate of 15 hours of work. And it's a flat rate of 12 if they don't track it. And it can be less than 12 if it is tracked. Three, the actual hours worked of the employee are all that really matter. They can be in the home waiting to be called to work, but attending to their own private affairs, sleeping, watching TV, making their own dinner. But if they're not actively working, that isn't compensable work. So it's a way to have an employee be on call in the home, but not pay them for that time, which a regular employee would be if they're required to stay in the home on call. And the way that gets dealt with is either the employee tracks their hours of work and is paid for the active hours of work, or you can say, we're not going to track your work, we're just going to give you a flat rate of 12 hours a day. But the maximum rate, even if they track, is 15. So you're not paying for 24/7 care by an employee. You're paying usually an upper rate of 12, maybe 15 hours, typically less than that. Hours of work are also really important. Now, one of the things we didn't talk about under the ESA is that most workers have a maximum weekly hours of work of 48 hours a week. You can agree to go over, but unless you have that agreement, it's 48, and some daily limits on hours of work. So certain minimum time off and so on. Those rules don't apply for residential care workers. They're just required to have 36 hours of consecutive time off per week, so a day and a half. And that can be non-consecutive if they agree. You just have to make up the time elsewhere. So that's a really big benefit for people looking to hire in a cost-effective way somebody to actually support somebody in a microboard setting who lives in the home. Now, I will say there is some risk in using this. It is one that we have seen, even though the law seems fairly clear in our view, we do know that the Ministry of Labor has been looking to tighten the application of this special status and there's been some case law going after it as well. We still think that, a properly argued case will come out on top. We haven't seen many of these properly argued cases, but there is some risk. And if you're going to take this route, good idea to get some legal involved, because if it's mismanaged, you can end up with some big bills. Now, another class, homemakers. These people work in homes they don't own, or that the employer doesn't own or rent. In short, a pretty rare occurrence in our sector, and they do work in their own home to produce things, generally not going to apply in our sector. But think about somebody who's making, widgets in their own home for the employer. Doesn't really matter for us. But then there's other special categories we think about, house mentors, housemates, or lodgers. These are basically it's like a supportive roommate arrangement. We do see this from time to time of you basically have somebody live in the home with the person supported. They're not providing supports, but they're just there to sort of keep an eye on them. If somebody needs a call for help, that person's there. It's a practical reality that this arrangement exists. There are some employment risks to it, because if you're actually expecting a person to do these responsibilities, and especially if you're paying them to do that, you start to lean into the contractor employee range. But it's a reality, I think, of the world that these arrangements do exist. And for our last slide here, and we'll have some time for questions just there at the end. When do you get us involved? When do you get specialty advice, get legal help? Well, there's a bunch of scenarios I would say are worth doing this. Off the bat, I think it's a good idea, and this is not on the slide there, to have a lawyer draft a brief employment agreement for you, just a template to use, because this is a pretty good protection against a bunch of problems that can arise down the road. So that's the first one I'm going to say. But when do you get a lawyer involved in the day-to-day management? Well, one, if you're dealing with some sort of a novel issue, something, a new type of relationship, and you're not sure, is it an employment relationship or is it a contractor relationship? If you're worried about the risk there, having a quick consult with a lawyer can be useful. If the employee status is in question. So if the employee says, you know what, I think I might be an employee, but you said I'm a contractor, that's a good time to get a lawyer involved to get a quick consult and say, what's our exposure here? What do we do? Because sometimes you can negotiate your way out of that. Sometimes the worker is wrong. If there's been an injury or an accident, that's a big one. If somebody injures themselves, you're probably going to want to get some quick legal advice. If the worker asks about or makes demands about their rights, if you want to end the relationship, that's a good time to get some legal advice. So for example, if an employee says, not just, if they say you're supposed to be paying me vacation pay of X, you're paying me Y, good idea to get a little legal advice involved. If the worker files a complaint or indicates they might do so, or in the event a government agency contacts you about the employee, or if a lawyer on behalf of the employee contacts you, that's a very good time to get a lawyer involved. And those can be things like Revenue Canada, the Human Rights Tribunal for Ontario, which is the decision-making body. We've seen families served with human rights applications, Ministry of Labor complaints, WSIB investigation. All of those are good opportunities to get a lawyer involved. In fact, we'd say it's a very good time to get a lawyer involved there, because that typically heralds a legal proceeding. And it's not a good idea to defend yourself in those unless it's unavoidable. One piece I haven't gone into yet that's up there is if an employer requests accommodation. So if somebody says, I need you to make a change in the workplace, and it's not something you can just say yes to without much trouble, you may want to get a lawyer involved to advise, what are we supposed to do here? But generally, most of the day-to-day, if it's well set up, you won't need to get a lawyer involved. But if any of these special circumstances arrive, it's a good time to call us or somebody like us. All right. Now I realize went a little longer than anticipated, but that is the end of my part of the presentation. I'm happy to take any questions at this point. And as Karen said at the beginning, while I'm limited from answering questions about specific circumstances, I'm happy to answer general questions, talk about best practices, things like that.